Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and I'm the owner and managing attorney at the firm. If you are new to our firm, new to our Facebook page, our firm is dedicated exclusively to helping couples across the nation and across the world and navigating the U.S. immigration process. I have gone through the immigration process personally with my husband, and I know all the feelings that come with navigating an immigration journey. And so, the purpose of hosting these weekly Facebook Lives is that we know here at Immigration for Couples that it's so important to have clarity and information as you're going through your immigration journey. And we also created a free resource center at immigrationforcouples.com. We have lots of guides, lots of informative information about the options that are available to couples and also how to prove your relationship is real. We have a guide on that as well. So check that out, regardless of whether you're, in the middle of your immigration journey or just starting out. Our free resource center has helped a lot of couples. So immigrationforcouples.com. And for these Facebook Lives, we have a lot of viewers who watch and join us here. I see we have some individuals here with me now, coming weekly. Anna, good morning. Oh, I love the updated picture. That's one cute puppy. And Lisa, good morning. It's so great. Yes, I am grateful for this time too. I think it's so important as human beings that we are in community, especially for those of us who are going through an immigration process, to know you're not alone, to get clarity and to have that support. And so that's exactly why we host these Facebook Lives every week. And so if you're watching this on the YouTube channel or one of our other social media pages, we invite you on over to join us for our weekly chats. If you're catching this on the replay, please do a hashtag replay. Let me know, what are your burning questions? What is it that you're wanting to know about the immigration process? And I'd be happy to cover those questions in the next Facebook Live. The other topic that I have is in regards to the a NOID, a notice of intent to deny. So maybe you've heard of this, maybe you received one, hopefully not, but maybe you've heard of this, and I really want to provide clarity on what is a NOID, what's a notice of intent to deny. The question that I received, there was several different individuals on our YouTube channel that ask, oh no, they said, oh no, I received a NOID. What can I do? Can I fight this? Others have asked, I've heard of the NOIDs. I've heard of RFEs. What's the difference? What should I be aware of? And so I really want to provide clarity around what is a NOID? What is this notice of intent to deny? And if you receive one, what should you be aware of and what are the steps that you should take? So, a notice of intent to deny, just as it sounds, immigration has looked at your case and they've decided, we're pretty sure that we're going to give you a denial on your case. We don't see enough evidence. There's contradicting information. It doesn't look like you're eligible. So we're planning on denying this, and we will deny your case. And typically they give you, the max is 30 days. Typically they give you a month, and they say you have a month. This is your opportunity to prove your case one last time. The burden is high, and they're basically saying, we're planning on denying the case, and this is your last chance. And so they're giving you this one last opportunity, but immigration is pretty firm on their decision that they have looked at your case and it's likely that they want to deny it. So I know that's a scary thing to hear. And for most cases aren't going to receive a NOID, but they are definitely possible. And I've even seen them in cases for individuals who maybe, they were doing their own case and they didn't realize some of the contradicting information that they were putting on the record. They did that unwittingly, and that's heartbreaking. And then in other cases, the person might get this because they're just not legally eligible. Other things that I've seen are where there are individuals who were married and divorced in another country, and the divorce laws are complex, and maybe that divorce wasn't actually finalized before they got married. That happens more than you would believe. And that's part of what we do here, is when we're helping our clients, is really making sure that the documents that they're providing are the full and final divorce and that they're legally eligible to get married. So those are a few situations in which a NOID would be issued. And like I said, immigration is of the position that they believe that your case that your case should be denied, and they're giving you this one final chance. So what should you do if you get this notice of intent to deny? The first thing you should do is definitely read it. Typically read it. And when I read it, I mean, you're going to read through it and you're going to be in shock. You want to read it a few times. Typically they're long and detailed, and you want to make sure that you go through all of the information in there and write down the parts that immigration are saying are contradictory information, are parts where you're not in compliance with the law, and make sure you really understand what it's saying. The second step is don't just respond right away. It's really important that you take time to look through that information, and this is your last chance. And it's really important that you don't quickly respond with just anything, because you could taint your immigration record further by doing that. And you've heard me say before, if you've been watching our channel for a while, I'll be the first to tell you that you don't have to have an immigration attorney to help you in your immigration journey. It's advisable, but it's not legally required. But if you get a notice of intent to deny, it's really, really important that you have an immigration firm help you navigate that process. Because typically a notice of intent to deny is going to be very, very heavy and very nuanced in immigration law. And you could overlook things or not understand some of the legal jargon and doing the response on your own. And again, like I said, you could taint and further complicate your immigration record, making it even harder for you to refile or fix the problem in the future. So I highly recommend that would be your first step after you read through it. That's your first step. Read through it and get clarity on what is the issue, what are they saying about your case. And the second step would be, if you don't have an immigration attorney, that you seek immigration assistance for that notice of intent to deny. And then the last step really would involve you working with that immigration attorney. In some cases, immigration is right and the NOID is justified, and there would be a reason that you would just respond with, yes, we agree, and finalize that record, and then see if there are options to fix their case moving forward. So that's step 3, but that would be under the legal advisement of an attorney. That's not something you would do on your own. But figuring out for step 3, is this something that I can overcome? Are there options? And if there's not, responding and agreeing with immigration, clarifying your record once and for all. Or the other part of step 3, the option would be, is there a way that we can overcome this problem? And then setting a strategy for putting yourself in the best position to overcome that notice of intent to deny through evidence and explanation. So I know that's a lot of information, but NOIDs are a very complex beast. And I just wanted everybody who's listening, to have clarity about, like I said, what a NOID is and what are the steps that you should take. And NOIDs are different than a request for evidence, because a NOID is saying, we intend to deny your case, whereas a request for evidence, they're saying they will deny your case as well, but it's not to that same level. Usually with a request for evidence, it's a matter of there wasn't quite enough relationship evidence, or there's some evidence that's missing, but immigration isn't to that point of, we're definitely going to deny the case. RFEs are something to take very seriously, and I discussed that in other videos, because if you don't properly respond to a request for evidence, then it would lead to a NOID, a notice of intent to deny. So I hope that provides you all with clarity. If you have follow-up questions or other questions on other topics, please don't hesitate to reach out or do a hashtag replay and let me know what your questions are. All right. I have a few. Yes, indeed. Too scary to take the risk of doing it on your own is what I'm assuming is what you were bringing that comment up for sure. Okay, this is a good question. Lisa, you always have good questions, creative questions that maybe I haven't always been asked. But how does the lottery affect people? Do you still apply for the spouse or fiance visas? I don't really understand if there is a difference. So you're talking about the diversity visa lottery, and just like it sounds, it's an immigration lottery. I think that's kind of cool. So the diversity visa is one of those types of immigration benefits. It's not guaranteed. And just like playing the lottery, it's just a lot of luck. It's just a luck of the draw. And it's not available to individuals from all countries. The diversity visa lottery was created with the intent of diversifying the United States even further, giving opportunities to individuals from countries who typically don't have an easy pathway to the United States, or rather don't have a high volume of immigrants from that country. So that's a diversity visa lottery in a nutshell. Yes, we definitely have individuals who have done the diversity visa lottery in the past and weren't chosen, or who are in the middle of that process. And the difference between that and the spouse or the fiance visa is that the spouse or the fiance visa is something that's written in immigration law. These are the laws, these are the eligibility requirements. If you meet these requirements, if you can prove your relationship is real, you can be approved for the visa and approved for your green card to be able to live in the United States. So there's a clear pathway, a clear set of eligibility requirements. If you're able to meet them and prove them, then you can get approved to come to the United States. Whereas the diversity visa lottery is pure luck. So yes, it's possible for individuals to have more than one immigration option pending or going at any given time. So great question. I really appreciate your really interesting and unique questions every week. All right. It looks like I don't have any other questions from anyone else. Going once, going twice. All right. Well, it was great spending today with you. Again, if you are looking for oh yeah, you're very welcome. You have an amazing week as well. All right. And here's that link to our free resource center, immigrationforcouples.com. Please share it with friends and family and anyone who might be needing support as they're navigating their U.S. immigration process. Have a wonderful week, everybody. I'll see you next week. Take care.